What aircraft escrow companies do and why they matter. Hello, this is Forrest Owens. I'm an aviation lawyer, a private pilot, and FAA licensed airframe and power plant mechanic. Let's begin with the foundational point. An aircraft escrow company is not merely a bank account with a nice label. In an aircraft transaction, the escrow company is the neutral closing desk that coordinates money, title, FAA filings, lien releases, and timing, along with KYC due diligence. That matters because aircraft are not transferred the way cars are and are not exactly the way real estate is transferred either. The governing federal framework is built around registration and recordation. Title 49 of the United States Code, Section 44107 and 44108, and 14 CFRs Part 47 and 49 establish what documents may be recorded, how the FAA indexes them, and why filing times matter against third parties. The FAA itself makes the practical point in plain language. Its clear title guidance explains that aircraft records contain liens, security documents, and releases filed with the Aircraft Registration Branch and found to meet recording requirements. In other words, the transaction is only as clean as the record and releases behind it. So, what does the escrow company actually do? First, there is a neutral escrow account for the buyer's deposit and closing funds. Second, it orders and interprets the title search. Third, it collects the seller's transfer documents, lender payoffs, lien releases, and registration forms. Fourth, it coordinates the exact sequence of signing, funding, release, and filing. And finally, it distributes funds only after the agreed closing conditions are satisfied. That sequence is not administrative fluff. It is at the heart of risk control. If the seller is paid before the lien release is in hand, the buyer may own an aircraft with an old security interest still on the record. If the bill of sale is signed but not properly filed, the parties may have a gap between economic closing and legal protection. If names, serial numbers, or entity details do not match, the registry may reject the filing and the entire closing posture can wobble. AOPA described the closing role well in 2024. Once the parties authorize disbursement and closing, the escrow agent releases funds to the seller, including any lien holders, and the title documents are dated and submitted to the FAA. That one sentence captures why escrow is so important. In aircraft deals, money and title do not move safely unless they move simultaneously. There is also an important legal distinction that sophisticated clients should understand. FAA registration is not proof of ownership in the broad commercial sense. Part 47 expressly says that registration is not evidence of ownership in a proceeding where ownership is at issue. The registry records and index documents. It does not adjudicate who is right in every private dispute. That is why transactional discipline matters so much. So, why are escrow companies important? Because they reduce the chance that the parties close on assumptions instead of documents. That they create one controlled table for deposits, wiring instructions, payoff letters, lien releases, bills of sale, security agreements, and FAA submissions. In in a large turbine transaction, that discipline is not a luxury. It's a closing necessity. In short, an aircraft escrow company serves as the neutral control center for the transaction. It protects the buyer from paying too early, protects the seller from delivering too early, protects the lender by coordinating recordation, and protects everyone from the chaos that follows a mis-sequenced closing. I'd like you to take this away and remember this. In an aircraft deal, Escrow is not about convenience. Escrow is about synchronizing title, money, and FAA recordation before risk outruns the paperwork. Why Oklahoma City became the center of aircraft escrow. Now, let's answer the practical question that clients often ask. Why are so many aircraft escrow companies based in Oklahoma City, Oklahoma? The short answer is geography backed by federal structure. The FAA registration branch is in Oklahoma City. The FAA's public contact information lists the FAA registration branch and registry building in Oklahoma City. And the Civil Aviation Registry is also the United States entry point for certain Cape Town International Registry filings. So, the city became the natural center of gravity for aircraft closings. Historically, proximity mattered even more because original paper documents, same day troubleshooting, and in person delivery could determine whether a closing happened on schedule. Today, fortunately, the system is more modern. The FAA's CARES platform now provides limited online registration services, and the FAA's 2025 procedural rule updated parts 47 and 49 to reduce burdens tied to original documents and to end the old stamping practice. But the registry itself is still there, the legal infrastructure is still centered there, and the industry experts that grew around that infrastructure is still concentrated there. That is why Oklahoma City is not just a place on the map, it's actually an ecosystem for the registry. Title companies, escrow officers, document specialists, and registry facing professionals built their practices around the Civil Aviation Registry because that is where the federal record lives. NBAA and AOPA both reflect that practical reality. NBAA notes that purchasers and sellers of new and used aircraft use title and escrow services in Oklahoma City for deposits and disbursements of the purchase price. AOPA similarly explains that aviation title and escrow companies do the title search, verify and file FAA documentation, and hold money in escrow until closing. There is another reason Oklahoma City matters. Aircraft closings often involve more than domestic registration. Large turbine transactions frequently include financing, cross border interest, engine collateral, and Cape Town filings. Section 44107 designates the FAA Civil Aviation Registry as the United States entry point for the International Registry, and that is for eligible aircraft and engines. The FAA's current guidance requires the filings of AC Form 8050-135 to obtain the authorization code for the International Registry. That means the closing often touches both the domestic FAA record and the Cape Town system. This is where a good escrow company earns its fee. It does not merely push paper, it understands when a domestic bill of sale must be matched with a lender security agreement, when a prior lien must be released before disbursement, when Cape Town authorization must be obtained, and when a registration package is vulnerable to rejection because the buyer name on the application does not match the evidence of ownership. Now, let's consider a simple example. A buyer forms a special purpose LLC 1 week before closing. The purchase agreement still uses the principal personal name in one exhibit. The bill of sale uses the LLC. The wire instructions use an abbreviated entity name, and the registration application uses a slightly different legal name. That may or may not sound minor. It's not. In aircraft transactions, small naming errors become filing problems, and filing problems become closing problems. An Oklahoma City escrow company that lives in this system sees those problems before the parties wire 7 or 8 figures. So, the reason these companies cluster in Oklahoma City is not folklore. It is the direct result of the location of the Federal Registry, the concentration of transaction expertise around that registry, and the market's need for specialists who can manage title, filing, and funding in one coordinated process. So, in short, Oklahoma City became the home of aircraft escrow because the FAA record is there, the transaction knowledge base grew there, and the industry still benefits from having experienced professionals close to the place where the recordation system operates. I'd like you to take this away from this. Aircraft escrow companies are commonly based in Oklahoma City because aircraft closings are built around the FAA registry, and the registry made Oklahoma City the nation's aviation closing capital. Where transactions break down and why escrow may prevent disputes. Finally, let's discuss where aircraft transactions most often break down and why a skilled and experienced escrow company can be the difference between a clean closing and a later dispute. The first failure point is the title search itself. The FAA explains that clear title means there is no unreleased chattel mortgage, security agreement, tax lien, artisan lien, or similar document on record against the aircraft. That sounds simple until the title search reveals a decade-old lien, a missing release, or a gap in the chain of conveyance. In that moment, the escrow company becomes a problem-solving desk. It's not just a wire desk. The second failure point is timing. Under Section 44108, a conveyance or security instrument that may be recorded is not fully protected against third parties until it is filed for recordation. And the Supreme Court's decision in Philco Aviation versus Shackett remains the classic warning. Undocumented or unrecorded transfers cannot defeat innocent third parties. That case is memorable because it teaches a practical rule every client should understand. An aircraft deal is not safely closed just because the money moved and the keys changed hands. The third failure point is assuming that the FAA registry decides ownership in the broad commercial sense. It does not. Part 47 says registration is not evidence of ownership when ownership is actually in dispute. So the parties still need a coherent contract stack, proper entry authority, valid signatures, correct delivery mechanics, and an escrow process that aligns the documents with the economic deal. The fourth failure point is lender and international complexity. In a financed turbine aircraft deal, closing may require a security agreement, recorded releases, payoff letters, and if the aircraft is Cape Town eligible, entry point authorization and international filings. Miss one step and the lender is exposed, the buyer is exposed, or both. Good escrow professionals understand that the aircraft, the engines, the domestic filing, and the international filing may all have to tell the same story at the same moment. AOPA captured the real-world problem well when it noted that the title may have an old lien that should have been released years ago. The owner may be deceased, or the transaction may involve import, export, or international registry issues. And that's exactly right. Aircraft closings fail because they are fact-intensive, document-intensive, and very sequence-intensive. There is also a client educational point here. Escrow companies are important but they do not replace counsel, tax advisors, brokers, lenders, or maintenance experts. Escrow protects the mechanics of the closing. It does not decide whether the purchase agreement properly allocates discrepancy risk, whether the tax structure works, or whether operational control is compliant after closing. A sophisticated closing team knows the escrow company is central, but not solitary. So, what should a buyer or seller expect from a strong aircraft escrow company? Expect a documented checklist. Expect title work early. Expect payoff coordination before closing day, not on closing day. Expect exact matching of names, serial numbers, and registration details. Expect coordination with counsel and lenders, and expect the company to refuse to disperse until the written closing conditions are actually satisfied. Here's something to remember. The most expensive aircraft closing mistakes are usually not dramatic mistakes. They are sequencing mistakes, naming mistakes, and release mistakes. That is why experienced escrow professionals matter so much in turbine aircraft transactions. In short, aircraft escrow companies matter because they convert a complicated legal and financial event into a controlled process. And Oklahoma City matters because the process still revolves around the FAA registry and the professionals who built their practices around it. I'd like you to take this away and remember this. In aircraft transactions, escrow is the discipline that keeps title risk, filing risk, and money risk from colliding on closing day. Thank you for your interest in this topic. This information is provided for informational purposes only, and it should not be construed as legal advice. Questions are welcome. Please direct those questions to admin@aviationlegalcounsel.com. We look forward to helping with your aviation-related legal needs and addressing your questions with precision.